Yeah, so jurors are instructed until the final deliberations they can't discuss the case. But what do you? As soon as you're told, I mean, it's just like it's a person, it's my kids, it's anybody. As soon as you're told don't go there, people go there.
They do discuss it,
and they Google this stuff too.
And in a week trial, a 2-week trial, it helps them remember things. What did you think of that witness, etc., rather than trying to bring it up later. And the other issue is on motions. For instance, don't file a motion, and if you file a motion and don't call it up for a hearing, the judge is going to assume that you didn't think it had any merit.
That's interesting.
If you file a motion for a continuance, even if all the parties agree, you have to still have a hearing. It cannot be granted without a hearing. And finally, on motions, this is arguments to the judge. This is from Judge Barbara Wallace from St. Louis County, a top circuit judge, now retired. She did a lot of judicial education to the judges in Missouri and elsewhere. This is from her. More is not better, it's just more. Come in with your 3 strongest cases. Don't repeat yourself. The judge is not deaf. She gets your point. And so remember that. Call up motions. Don't assume they're granted, even if everyone agrees. They have to be called up. And secondly, more is not better.
So more is not better. So that goes to my first point I wrote. And so one of my more recent favorite quotes from Mark Twain is, if I had more time, I would have written a shorter note. So, and when I teach other lawyers to write, you write all this stuff for the trial court, and then you have all this is the law and here's the facts and blah, 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 blah. And then you have your conclusion at the bottom. I say, take that conclusion, stick it up at the top. Because if you're a trial judge and you got 50 motions to deal, you don't want to go through 10 pages to figure out what's saying. And just make it simpler. Never say anything twice in a written motion. Say, you should compel production of this document because of this. You should give me this. The other side's not doing this. Give me this deposition. Continue this case. Dismiss this case because this. Don't dismiss. Say it there. Give just the facts you need, and then tell what the law is. And then if you're editing a document, if there's anything that's you don't need, take it out. You don't need to do that, and the judge already has too much to read, right? And then that translates to your oral argument too. If you don't need to say it, don't say it, just like Judge Wallace and you say. And then that dovetails with in trial, and that's true in motion practice. But in trial, it's the same thing, because the adage is, and it's true, the simpler case wins. If your case is short and simple and clear and persuasive, that is going to be more of a winner or more persuasive than a long, complicated case, whether you're on the plaintiff or the defense side. So my corollary to what you said about motion argument is that the simpler case win. If you can't put your case on quickly, if you don't have what the defendant did wrong zoned in and narrowly tailored, you need to figure out why. You're there for a specific purpose at trial or at a motion hearing. You're not there to let everybody listen to how smart you are or what a great person is. You're not there to stoke your ego. You're there to win your client's case, be an advocate, win the motion, win the injunction, win the jury verdict, or defeat one on the other side. That's your purpose. Narrow and filter why you were there to that purpose.
Exactly, whether it's the judge or the jury. And don't always be professional, even if the other lawyer is not. Don't make the judge be the parent. Don't make little snide comments. Be professional and be polite. Don't be argumentative. And definitely don't be argumentative to the judge.
And let me talk about that in a minute, but on the focusing the case, one of the things that you learn in law school is the Socratic method, question the question. So even if you prepare a motion or a brief or an argument or something, always be prepared to put it away for a day, step back and look at it and say, do I really need to say all this? Do I really need to do all this? Have you seen lawyers not do that? They get kind of stuck in the way they want to do. Tell me about that.
I think cutting things down is very important. Trial judges and appellate judges. I'm much more apt to read. As I said earlier, I would ask lawyers to give me a brief outline of their points and attach the cases for me. In those days, there wasn't as much on the internet. Probably today, I even could find the case on the internet. I don't know. But brief, concise, make your point, and then let it go. Sit down.
Under promise and overperform to a judge and to a jury. And I've had many trials where don't get in a rut. Don't put your blinders on and then just kind of go through. You got to look and see what the jury's doing. If the jury's got the point, sit down. You may have another witness. You may have 7 things. You always need to adapt in a trial. You may walk into a trial and need to prove a lot of points, and the defendant may give them up. I've had many cases where they go quicker than I think because I start cutting documents and start cutting witnesses, and you need to. Especially new lawyers, you sit and you look at your outline and you have all the questions you have to ask, I see you nodding. You have all the questions you have to ask and all that, and you sit and go to it. You don't realize that the witness already gave that point up. You already won it. You may have 7 more questions to get there, but you already got it. Move on, because if you then fill up the space with a lot of BS, you're going to dilute the power of that admission you got, and the jury's not going to be able to ferret that out.
Yes, that's correct. And I mean, I think we're giving the same message over and over, but it's an important message.
Well, should we move on?
Well,
Is that what you're saying?
No, don't bore the jury.
Did I already bore them with over talking about this?
No, I don't think so, because this is really important. You have to know what you want from each witness, and think beforehand what you want from each witness, and make your point and stop questioning on irrelevant matters. That's a recommendation from my friend Marianne Sade, one of the top trial lawyers in Missouri. The jurors will remember your important point and not 20 others. So make your point, especially in cross-examination. In cross-examination of a witness, know what you need to get from that witness, get it, and then sit down.
Can you tell me, do you have any examples or any recollection of times when people have done that well, or times when people have not done that well?
No, not specific examples.
Okay.
There was one expert, and I had a 3-month trial, my first civil trial, and it was over the hog farms in northwest Missouri. And one of the experts was testifying about the anaerobic lagoons, which you know what they contained. And the lawyer was going on and on and on, cross-examining him, irritating all of us. And finally, the lawyer asked the expert, well, now, how big are those lagoons? And he said, enough for all of that anaerobic substance in there to fill this courtroom. And everyone burst out laughing. The expert was pretty irritated by the lawyer.
That's funny. Yeah, that makes the point. And I've had... I've watched other lawyers do this, and they get a great point, and I'm sitting there thinking, sit down, move on. And then they go on and blah, 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 and they lose the power of the point. You got to remember that jurors are also, they watch these lawyer shows, and they see 1.5-minute videos on YouTube. They expect the moment to be done, especially with the way our media is now and the way people are used to getting information. It used to be you'd watch, 5-hour long documentaries. No, people want their information in short little capsules.